Hi, welcome to this Law Study Club video to help you to revise pure economic loss in tort law for A-level law. Liability for pure economic loss is probably one of the hardest parts of A-level law because it seems like quite a niche part of the law and the cases involved are a bit complicated. But actually there's a fairly simple general rule and one key exception to it that you need to learn. We're going to start with an introduction to pure economic loss before working through that general rule and the exception that was created in the case of Hedley Byrne, before looking at the requirements of the special relationship under Hedley Byrne, which will form the key part of any answer to a problem question in an exam. All the losses we think about in tort law are in some way economic. The courts apply monetary value to them in order to award compensation. Sometimes this is fairly straightforward, like money to fix a damaged car. Sometimes it's a bit more complicated, like deciding what monetary compensation we might award for the pain of a broken leg or for a psychiatric injury. But a pure economic loss is an economic loss that's not caused by physical injury to the claimant or damage to the claimant's property. Most of the time, it takes the form of lost profits, money that could have been made but wasn't because of the defendant's negligence. The leading case on working out what is and isn't a pure economic loss is Spartan Steel v. Martin. You might know that in this case, the defendant company was digging up a road when its workers negligently cut through a power cable to the claimant's steel factory. A claim was brought by Spartan Steel for both the damage to some steel bars that were on the production line at the time of the power cut and for the profits they lost during the 15 hours the factory was closed. Spartan Steel is such a helpful case because it gives us examples of losses that are and aren't purely economic. The costs of the steel bars that were on the production line when the power cut happened were not purely economic because that financial loss was directly caused by damage to property, i.e. damage to the steel bars themselves. But the lost profits while the factory was closed were purely economic because they weren't caused by any damage to the claimant's property or personal injury to the claimant. The general rule is that pure economic losses can't be recovered. The claimant won't be compensated for them. So in Spartan Steel, the claimant received damages for the steel bars that were damaged on the production line, but not for the lost profits while the factory was closed. Now this might seem a bit legally dubious. Why should the claimant be left out of pocket when the defendant's negligence has caused them to lose profits? There are two justifications, both based on public policy. One is that claimants are usually businesses seeking to make a profit, so losses such as these can be seen as one of the risks of doing business and can usually be insured against. The other is that it avoids crushing liability for a defendant. Imagine a defendant negligently cut the power supply to all of central London and was held liable for all the lost profits of every business while the power was off. The defendant simply wouldn't be able to cover all of the losses. The general rule on pure economic loss has been in place for a long time and was upheld in the early 1950s in Candler v. Crane, in which Lord Denning dissented and argued that losses ought to be recoverable. In Hedley Byrne v. Heller in 1963, the court accepted Lord Denning's arguments, a nice example, by the way, of a persuasive precedent from a dissenting opinion, and created a very limited exception to the general rule on pure economic loss. In Hedley Byrne, it was held that pure economic losses can be recovered if they resulted from a negligent misstatement by the defendant and there was a special relationship between the defendant and the claimant. So the first part of the exception under Hedley Byrne is that the losses must result from a negligent misstatement. This means something that the defendant said, not something the defendant did. So most of the cases you'll come across involve someone receiving bad advice or faulty information from the defendant, and this leading to them losing money. The second part of the exception is that there was a special relationship between the defendant and the claimant. This special relationship essentially boils down to two features. The defendant must have voluntarily taken on responsibility for whatever decision the claimant is making, and the claimant must have reasonably relied on the defendant's statement when they made their decision. But Hedley Byrne lays out 5 core requirements for the special relationship, and these are still good law today. In some ways, a 5-part test can be a bit annoying to learn, but at least it makes the law pretty clear and gives you lots to look for in a problem question. These requirements are: the defendant claimed some special skill or expertise in the subject, the claimant reasonably relied on the misstatement, the misstatement was made directly from the defendant to the claimant, the defendant knew the specific purpose for which the claimant was relying on it, and the defendant gave no disclaimer to the claimant about the status of the advice. If we work through the requirements one by one, the first is the defendant claiming some special skill or expertise. Now, there are two important points here. It doesn't really matter whether the defendant was genuinely skilled or expert in the subject, as long as they're presenting to the claimant as though they are. This is important because the defendant has usually made a bad mistake by the time the claim is brought, so maybe they aren't too skilled or expert at all. But the claim can hold as long as they appeared to be. The other key point here is that Hedley Byrne doesn't require the defendant to be a professional in the subject, and we have cases like Chowdhury v Prabhakar that remind us that the statement might even be made between friends in a casual or social situation, but the claim might still be upheld if the friend purports to be a subject expert. The second requirement is especially important. Firstly, the claimant must have actually relied on the misstatement. If the claimant heard the defendant's misstatement but then took lots of other advice and relied on other people, they won't have a claim against the defendant. This reliance must also be reasonable, which often overlaps with the other requirements because, for example, it would be unreasonable to rely on a statement made by someone who didn't claim to know about the subject. The statement must have been made directly from the defendant to the claimant. This is partly to reinforce that the defendant must be voluntarily taking on some responsibility towards the claimant, which they wouldn't be doing if the advice was passed on by a third party. This rule also prevents huge numbers of claims being made after a misstatement is published to lots of people, like advice being published in a newspaper, for example. The defendant must know the specific purpose for which the claimant was relying on their misstatement. This reinforces the voluntariness of the defendant taking on responsibility towards the claimant, because it means that the defendant has to know why the claimant actually wants the advice. This stops claimants from bringing claims against defendants who had no idea that they were even giving advice, or had no idea what the advice was going to be used for. Now, the final requirement brings down a lot of claims for pure economic loss. The defendant must have given the claimant no disclaimer about the statement they made. If the defendant says something like, "Don't take my advice," or "You'd have to check this, but," or even "Don't quote me on this, but," then the claim will probably fail. For this reason, lots of businesses involved in giving advice, like accountants for example, might include in their terms a disclaimer that no claims could be brought against them for pure economic loss. So if we return to that summary of the special relationship that we started with, we can say that the 5 requirements from Hedley Byrne really amount to a voluntary assumption of responsibility by the defendant and reasonable reliance by the claimant. The need for that voluntary assumption of responsibility by the defendant can be seen in Caparo, in which the defendant company had no idea that the claimant company was even reading the accounts the defendant had created for a third party, so couldn't be said to have voluntarily assumed any responsibility towards the claimant, and the claim failed. The need for reasonable reliance by the claimant can be seen in J.E.B. Fasteners v. Marks Bloom, in which the defendant made errors in producing a set of company accounts, but the claimant already knew about these errors when they acted to take over the company. So they didn't actually rely on the accounts produced by the defendant, and again the claim failed. Most pure economic loss claims arise from commercial settings, but we do know from Chowdhury that a claim can also arise from a social situation. In Chowdhury, that claim arose from advice about a car given from one friend to another. So now let's check our understanding of pure economic loss by working through this scenario. Farah and Jess were in their 6th form common room looking at dresses on a vintage clothes website. Farah told Jess she knew everything there was to know about designer clothes and that a particular dress was being sold for £20 when it was worth at least £200. Farah told Jess, "If I had £20, I'd buy the dress myself and resell it. If you don't believe me, ask your textiles teacher." Jess thought about asking the teacher for advice, but decided to go ahead and buy the dress straight away. When the dress arrived, it was clearly a poor imitation, and Jess was unable to resell it at any price, so she gave it to a charity shop. So our question is whether Farah can be held liable for the loss suffered by Jess. If you want to work through the scenario independently, pause the video now and then hit play to get a worked solution. We need to start by identifying the loss. We can see that Jess has spent £20 on the dress and that this money is lost entirely because she gives the dress away. Applying the rules from Spartan Steel, the loss is purely economic because it isn't accompanied by any personal injury or damage to Jess's property. So we know that the general rule on pure economic loss wouldn't allow any claim from Jess against Farrer, unless we can find that the loss was caused by a negligent misstatement in the context of a special relationship. We can find a negligent misstatement when Farrer tells Jess that the dress is seriously undervalued on the website. This is a misstatement because it isn't true, and it's negligent because Farrer clearly hasn't taken enough care in checking whether the dress is authentic. So that leads us into the requirements of a special relationship from Hedley Byrne. We can see that Farrer purports to have special expertise about the subject when she tells Jess she knows everything there is to know about designer clothes. We can also see that Jess does rely on the misstatement because she immediately bought the dress after hearing Farrer's advice. The statement was made directly by Farrer to Jess, and Farrer knew the purpose for which Jess wanted the advice, because she specifically said she would buy the dress and resell it herself if she had the money. So far, so good on the special relationship. But then we have to decide on the status of Farrer's comment, "If you don't believe me, ask your textiles teacher." Farrer might argue that this amounts to a disclaimer, and perhaps that it makes Jess's reliance on the misstatement unreasonable. But Jess might argue that "if you don't believe me" isn't quite the same as saying "don't take my advice." With good reasoning, either of these solutions would likely be accepted in an A-level question, but I'm not convinced that the phrasing is good enough to amount to a disclaimer. So I would conclude that all the requirements of the special relationship are there and that Farrer is liable for the loss. When it comes to remedies, we have three different numbers in the scenario that might confuse us. We have the £20 that Jess paid, the £200 that Farrer said the dress was worth, and the £0 that Jess eventually ended up with. In tort law, the aim of remedies is to put the claimant back to the position they were in before the tort occurred. So the court would just award Jess the £20 back that she paid for the dress. That's because before the misstatement, Jess had no dress but had £20, so awarding £20 in damages would put her back in the same position. So you should now be able to explain what pure economic loss is, apply the general rule that pure economic loss can't be claimed for, and apply the exception to that rule using the special relationship rules for negligent misstatement from Hedley Byrne. Hit subscribe to get notifications on new tutorial videos and follow the link in the description to lawstudyclub.co.uk where you can find up-to-date revision guides, case lists and loads more resources for A-level law.